Well, good morning to everyone present. My name is Ankit Malhotra. I am a Felix Scholar from SOAS and I have a master's in international law that was sponsored by the Felix Foundation. I also have an undergrad and a law degree from India. I am now currently working as an associate in Justice A.K. Sikri's chamber. He's a retired Supreme Court judge and now sits as a international judge in the Singapore International Commercial Court and is also a member of Four Pump Court, which is a leading chamber in England. I am deeply apologetic for not being present for the colloquium. As much as a fun it would have been to be in Belo Horizonte, my time, the time difference, the travel time, and also my diary just does not allow me that. However, I am thankful to the organizers for allowing me to share my perspectives nonetheless on a topic that has now gathered steam and moss in my current legal research, but also it relates very well with the research assignments and topics that I work for with the judge. With that quick overview of what I am doing and what the background is, I'd now like to discuss the background of the paper because that is also something that is of equal importance, and that is that the dissection of the mechanisms through which international legal bodies assess, adjudicate, and enforce environmental norms and obligations. This research seeks to eliminate the evolving role of jurisprudence and its implications for global environmental governance. The object is not only to analyze current state of international environmental law, but also to identify the challenges and opportunities presented in the quantification of environmental damages. But to do so, one must propose pathways towards more effective and equitable solutions. And in pursuing this objective, the scope of this paper will encompass an examination of landmark cases and the jurisprudential trends emerging from international courts and tribunals. Through this analysis, the paper aims to contribute to the ongoing discourse among international lawyers, policymakers, and scholars on enhancing the efficacy, fairness, and environmental sustainability of international legal frameworks in the face of global ecological crises. Now, to start off with, it is also important to not only consider but also keep in mind the history or how we have reached the position that we now find ourselves in. For history happens to be one of those subjects that can not only teach us about the past but also prepare us for the future. One is also reminded of in a very famous quote by Antonio Gramsci, but one should park that for now and urge the members of the audience to focus their attentions on the transcendental arbitration, and that should be, at least for the purposes of this paper, used as the starting block. This case between the United States and Canada in 1941 was an arbitration that addressed a dispute between said countries over air pollution emanating from train smelters located in British Columbia, Canada, which caused damage to agricultural and forest lands in the state of Washington. The tribunal's decision, and we shall come to this again, but for now, I would like to share is that it underscored the obligation of a state not to allow knowingly its territories to be used for acts contrary to the rights of other states. But be that as it may, I now want to focus my attention on the jurisprudence of the International Court of Justice, which now finds itself busier than ever before, which again happens to be a point of concern and of discourse, but shall be parked there as is for now. But why this is important is because in the early parts of 2018, the International Court of Justice, but also the Inter-American Court of Human Rights, has significantly contributed to the evolving intersections of international environmental law and human rights through its landmark decisions. On the second day of February, the ICJ issued a judgment in the case certain activities carried out by Nicaragua in the border area. This focused on compensation for environmental damages. Shortly thereafter, on the ninth day of February, the Inter-American Court of Human Rights delivered an advisory opinion on the environment and human rights, underscoring the intrinsic link between the rights to a healthy environment and protection of human rights, particularly with the context of marine environmental protection in the Greater Caribbean. While different bodies, different courts set up in different geographical locations, what becomes extremely important and perhaps apparent as one progresses is that the parties belong to a certain region. And that is what is most important and should be kept in mind while discussing and revitalizing the points forward. But the ICJ's judgment stemmed from a decision of 2015, where the finding held that the Nicaraguans are liable for unauthorized activities within the Costa Rican territory, including the excavation of canals and military presence, which prompted a separate proceeding to determine the compensation owed by Nicaragua to Costa Rica for the resultant environmental damage. In contrast, the Inter-American Court of Human Rights and its advisory opinion responded by a request by Colombia to clarify states' obligations regarding environmental protection in the context of human rights within the marine environment of the Greater Caribbean, as one had reflected above. All in all, these offer a pivotal moment in international law, highlighting the increasing recognition of environmental protection as fundamental human rights and the complexities involved in quantifying damages and for compensation. The ICJ's approach in calculating the compensation owed to Costa Rica was marked by causation and precision. This is what the ICJ chose to decide and determine their fate. And in doing so, it held that the Costa Ricans had sought a approximate value in damages of $6.711 million based on an ecosystem approach that projected a 50-year recovery period for the affected area. Nicaragua, on the other hand, proposed a significantly lower figure of 188,000 US dollars and 500, arguing that evaluation based on replacement costs tied to domestic environmental conservation incentives is the right way to proceed forward. The court ultimately awarded Costa Rica 378,000 US dollars, a figure that starkly contrasts with the initial claim, but reflects the court's willingness and attempt to balance and come to an equitable consideration. The incremental approach, while prudent, diverges from the expansive view adopted by the Inter American Court of Human Rights, which emphasized the comprehensive obligation of states to prevent transboundary environmental harm. The court, in its advisory opinion, held that environmental potential and the damage thereof arising from infrastructure projects and other developments also must be accounted. The ICJ's meticulous examination of the specific environmental damages associated with compensation within the confined parameters of a bilateral dispute were also of importance. Therefore, an overall assessment of environmental impairment over attributing specific values to individual environmental goods and services was important. Therefore, capturing the holistic nature of the ecosystem affected also highlighted the court's reluctance to fully embrace either the party's proposed methodology for damage assessment or the ecosystem's impairment rather than on a detailed account for each category of environmental damage, as illustrated by the court's caution and navigation of the intricate balance that they strike thereon. I want to now dig deeper into the advisory opinion, and I should therefore spend further time on it because what it does in terms of marine protection for the Greater Caribbean region is that it focuses on fundamental points of environmental law, namely, causing significant environmental damage in and outside their territory must be regulated and supervised and monitored. Furthermore, the realization of effective and independent environmental impact studies are also of importance, and mitigation and contingency plans must be drawn out for potential damages. Furthermore, cooperation between states is also very important, especially keeping in mind the precautionary principles to protect the life and personal integrity of those in vulnerable regions. It is therefore also important to remember the guarantee of the rights to public participation, access, and information related to potential environmental harms, and access to justice in decision making could therefore affect the environment. Having said so, I now want to again return back to the International Court of Justice and the points that one had made thereon, only to add and reflect what was held by Judge Sima and others in the Gapchikovo Nagimuro's case, but also in the pulp mills case and the whaling case in Antarctica. Why this is important is because the reasoning and the judgments on compensation nowhere surveys considerably involve scientific landscape on short-term and long-term environmental damages, assessment for complex environmental phenomenon such as biodiversity, energy, air quality, and research materials, such as those involved in the construction of the regions. This would, however, been a visionary judgment, illuminating the scientific basis for interlocking states responsible for prevention, redemption, mitigation that were recognized in the advisory opinion. The court had least transparently discussed the evidence before it and made use of it. Having discussed this, I want to still remain with the International Court of Justice, but shift my playing field slightly now. And that is to now focus on what happened on the 19th day of December 2005, where the International Court of Justice lays down its judgment in the Democratic Republic of Congo versus the Uganda matter. That is because the case concluded the merits phase of a 6 year long dispute and litigation which concerned the violations of international law by acts of aggression perpetrated by Uganda against the DRC. The judgment found that there are references to articles of the UN Charter, specifically Article 2.4, and the violations expressed therein. However, the negotiations that followed therein in order to determine the quantum of damages were in vain. It ultimately became the ICJ's responsibility to decide the appropriate amount. On the aforementioned date, Uganda was asked to pay 325 million US dollars. The ICJ awarded the damages in the form of a global sum, invoking a special doctrine for awarding compensation. The global sum is an approximate sum of damages to a court which may be awarded by softening the rules of causation to protect the rights of claimant where it is warranted by the ideals of fairness. This note also argues that the global sum principle offers a flexible, holistic value in concerning and determining the damages and claimants faces a serious evidentiary question in this regard. This certainly is a welcomed approach, especially wherein human rights abuses have also been rampant. These brazen acts of violations were noted by the court. But here one must draw the distinction between a domestic legal system, where the principal function of awarding damages and compensation means that the law aims to restore the claimant to a position which it would have been besides the respondent's wrongful acts. To receive compensation, therefore, a claimant must establish inter alia a causal link between the respondent's wrong acts and the harm suffered. But the principle is not absolute, and this is what I want to focus on. Because in some instances, the quantification of harm is subject to considerable limits as to the degree of certainty and precision that can be expected. Damages and actions are anchored in competition law breaches, which are prominent examples for one's review. Whereas most civil law system jurisdictions allow a global assessment of losses under conditions defined in the statute. Say, for instance, the English principle of broad brush principle within the paradigm of equity. There is a matter herein which one can refer to in the London Borough of Merton. I shall encourage all fellow participants to consider this for the research as well. But the global sum principle exercise involves an assessment of the perceived or potential culminative effect of the harm suffered. The method is, by its very nature, imprecise, and the outcome may not accurately reflect the value of actual harm. The approach has thus been criticized for giving rise to too much uncertainty over those claimants' uh, positions. Therefore, what the court noted in paragraph 306 is that, and I quote, allow an unreasonable instance on precision to defeat the justice of compensating a claimant for infringement of his rights. This was held in another English matter of Asda Stores versus MasterCard. But what must one make of the global sum principle and the matter that we have just discussed? What must be the fate, equity, and the proposition of forensic difficulties is something that needs to be considered. As oppositely noted in the ICJ, the source of the dispute was complex and chaotic since it was an armed conflict where harm was suffered by both parties. The court held that while the claimants are ordinarily required to demonstrate a causal link between the wrongful act and the injury, as held in the judgment in para 93, uncertainty arising out of a similar set of circumstances that culminate in international wrongful acts must not bar the award from reparations. And this was something that was discussed in paragraph 106. In such circumstances, the court notes in paragraph 93, and I'm going to quote this here because this is very important, is that the court may make an award in the form of a global sum that represents an amount calculated on the basis of a range of possibilities indicated by evidence and consideration of fairness and equity. The main idea being that the causal link requirements are adjusted and evidentiary defects are pointed and remedies are made, taking into consideration the gravity and extent of the harm caused and the event that gives rise to the evidentiary issues. Having said so, what needs to be now noted is that this approach may be appropriate where the respondent is much better placed to establish causation, thus highlighting another equitable consideration that informs the judgment of global compensation and damages. The global sum approach has been applied in the field of investment law as well, and that is in the case of P.A. Casado. In an example of investment law disputes that gives rise to global damages, in an ICSID arbitration on the said case, it was initiated under Chile and Spain under a bilateral investment treaty that concerned the wrongs committed by Pinochet's regime, specifically the wrongful expropriation of the claimant's newspaper's enterprise. The tribunal awarded global damages, in no small part because of the wrongful acts committed decades ago. The tribunal was also explicit on the point that the award for global damages meant not just a way to overcome evidentiary difficulties, but also a way to conserve resources that would otherwise be spent on expert testimony. This highlights another practical consideration why such broad brushes on damages is important, and that being cost saving. Circling back to the DRC case and the global sum that was awarded in the ICJ, around 3% of that which was asked by the claimants, the court awarded compensation in the form of global sum to circumvent evidentiary difficulties. And this brings to mind another case, and that is Lupasna versus Romania, which further evidences this. That is because the case concerned a claim for damages arising out of a wrongful deportation of a businessman from Romania. The European Court of Human Rights was faced with the difficulty of quantifying the loss that arose out of Mr. So and so's inability to continue developing his business. The court made an award covering all heads of damages on an equitable basis in paragraphs 70-72 and awarded that he was liable only for 5.54%, and this is in relation to the original claim that he had made. This is yet another case which shows that the claimant received compensation, but the amount of compensation seems low compared to the harm suffered. Critically, the Lupasna case also offers little explanation as to how the amount of global sum was assessed, which gives rise to uncertainty regarding the fairness of such matters. But I still want to remain with this case because in paragraph 72, the court makes an important point which does not sufficiently rationalize the sum awarded, but merely points out that the decision has, quote unquote, regard to all the evidentiary evidences presented in its possession. This contrasts with the detailed reasoning of the ICJ in the Costa Rica versus Nicaragua case and the DRC case. While the ICJ awarded compensation that was significantly lower than what was asked by the claimants in DRC, The judgment carefully engaged with the reports submitted by the court's experts, reports of the United Nations, and other international bodies. Now, having discussed a large plethora of cases, it is also important to reflect on how one can improve the system. How can one make a possible and plausible change for improving the system? And in that regard, one can reflect on the following points. While diversity and inclusivity are important buzzwords of the 21st century, diversity, at least in this respect, can complicate efforts to create a cohesive international definition of environmental damage. Which brings me to the point that there is no definition which is universally accepted for environmental damage in international law. This aggravates the ambiguity and inconsistency further. Definitions vary across treaties, conventions, national laws, leading to challenges in enforcement and compliance. This lack of creativity and clarity hampers international cooperation and weakens the effectiveness of environmental protection efforts. But what also about the practical difficulties that are the classic rules of responsibility? Traditional legal concepts such as of responsibility, liability, and compensation are ill suited to adverse situations such as those of environmental damage, which is of transboundary nature. And this often involves cumulative effect, long term impacts, and uncertainties on the causal relationship. These classical frameworks struggle to accommodate the preventive and precautionary principles and measures necessary for effective environmental protection. The other point I want to focus on is on the inadequacy of traditional liability regimes. That is because they require direct causation and quantifiable damages, which does not easily apply to environmental harm. That is because environmental damage often results from a combination of factors, including systematic issues of industrial pollution, deforestation, and climate change. These factors challenge the traditional liability of frameworks and are ill equipped to handle the diffuse the situations that we face. What about development of new liability regimes? Here, I want to advocate for the creation of a new liability regime that can effectively address the nuances of environmental damage. These new regimes will not only incorporate broader concepts of harm, including ecological damage, loss of biodiversity, and the impacts on human health and welfare, but will be beyond immediate economic losses as well. And the last point I want to refer to on this slide is incorporation of environmental principles. The proposed liability regimes should integrate principles of environmental protection, such as those of precautionary pay, polluters pay, and the principles of sustainable development. These principles, in toto, emphasize preventive action, the responsibility of polluters to bear the costs of pollution, and the need to balance development and environmental protection and consideration. In the end, what I would like to say is that the landmark cases of those discussed above, especially the reference to the International Court of Justice cases from pulp mills to now where we are, where the court is now asked to opine on environmental responsibility of states in an advisory opinion. Issues of such nature will keep rising and are rising, not only in the International Court of Justice, but also in its other bodies, such as the International Tribunal for the Law of the Sea. These judicial decisions have reinforced the obligations of states to prevent transboundary harm, conduct environmental impact assessment, cooperate in environmental protection efforts. However, quantifying the damage that is done thereof remains one of the most complex issues challenging and facing international environmental law. These difficulties lie in assessing non economic damages such as biodiversity loss and in the transboundary nature of environmental law. Despite these challenges, international jurisprudence has made strides in developing methodologies for environmental damage assessment, as seen in the train smelter case from where we started to the Mox plant case of the Itlos and those others mentioned. In end, I would like to make two solid points, in fact, three solid points. First being there is a need for a greater integration of scientific and technical evidence into legal proceedings to improve the accuracy of environmental damage assessment. Second, The development of more coherent and unified approach to applying international environmental principles across different legal regimes would enhance the predictability and effectiveness of environmental jurisprudence. Third, and of equal importance, is that the increasing accessibility of international legal mechanisms for communities and for individuals affected by environmental harm could deharmonize or democratize the crux or the stigma that is attached, therefore allowing environmental justice to be ensured at a more equitable outcome. In navigating the path forward towards green justice, international courts and tribunals stand at the forefront of shaping a sustainable future. By continuing to evolve and adapt to the complexities of environmental law, these judicial decisions and bodies play a pivotal role in creating and crafting principles and practices that will guide global environmental law governance for years to come. With those words, I once again thank the organizers for giving me an opportunity to share my thoughts. Thank you very much.